judge has temporarily blocked several key parts of a controversial Texas law that's aimed at discouraging women from getting abortions. Among other things, it would require several doctor's appointments and an invasive sonogram before the procedure. Under the law, we are told women who want an abortion must first look at an image of the fetus or embryo and listen to the heartbeat. The judge ruled that was unconstitutional, saying, and I'm quoting here, the act compels physicians to advance an ideological agenda with which they may not agree, regardless of any medical necessity. The Texas governor and presidential candidate Rick Perry signed the law earlier this year. He says it would save countless lives by informing women about the procedure. The state is now appealing the judge's decision. Let's take this now to our legal panel, former prosecutor Joey Jackson and criminal defense attorney Rebecca Nitkin. And Joey, I want you again just to read this, or read it to you, and then you get your response in this. And it says the doctor would have to display the ultrasound image to the mom and then make the heartbeat audible and explain the organs to her. The judge said that part was unconstitutional. The judge right?
Well, here's the point. There's a political component to this, and that's not something for us to debate or discuss. A judge is not in the business of deciding whether law is good, bad, or even whether it's necessary. A judge has to evaluate it and determine whether it's constitutional, and I would suggest to you it is. And here's why, Trace. If you look at the law, what I would suggest is that it's informational. A doctor and a patient are together collaborating, and the doctor is simply giving information to the patient about various parts of the fetus. Now, compulsory information. Remember, the law was challenged on First Amendment grounds. Compulsory information is a very big part of what government does. You have manufacturers, and they're required to duty to warn about products. You have medications, and when we're giving medications, we're told what they're contraindicated with, what's contained in them. Food, we're told about our food and ingredients. So what I would suggest to you, Trace, is that this is nothing more than an informational statute requiring doctors to go over with patients reliable and adequate, necessary information about medical decisions that they're making.
And Rebecca, the judge clearly differs with Joey because the judge says this would force the doctors to make an ideological stand. Your thoughts?
Well, I love Joey, but we're on different sides of the fence on this one. Let me break it down for you. First of all, the law cannot be vague, and right off the bat, it flunks the vagueness test, because what are you going to do? You're going to have a doctor with a sonogram, and by the way, who's paying for these sonograms? But anyway, the sonogram's here, and he's going to say, I have a fuzzy picture here. And the next room, the doctor's going to be saying, I have a blob here, if it's a very brand new, like 3 weeks or something of that nature. And what is the doctor supposed to do? There's no direction there. Each room, something else is going to be happening. And how are you going to find out if the doctor's doing the job? Are you going to have a police officer in the room? Are you going to be taking the records from the women and saying, on this day, the doctor gave the sonogram, and the doctor sat with the woman who obviously the legislator believes is an idiot, because although that she's
Rebecca, the supporters of this law, let me just jump in, because the supporters of this law, what they're contending is that the reason that women, after they get an abortion, regret it is because they're not given all the facts. And the Texas lawmakers are saying, look, if we had a doctor sit down and explain to them exactly what's happening, maybe they would make a different decision.
Right, that's what they're saying, because all women are idiots and they just jump into everything, and they haven't spent a million hours pining over this decision that they have to make. And on top of that, if they're raped or they're victims of sex abuse and they're victims of child abuse or whatever, there's a special exception, but that is they have to get a certified copy, and they're swearing to it. So again, and step back on this, you know, what about HIPAA? I guess that that doesn't apply to the women either, because the federal law doesn't apply either, because all of these records are going to have to be available.
Trace, I understand Rebecca's frustration. I really do, in terms of enforcement and how you would do it. But you have to take a step back from that for a minute and just look at the law itself. And what I see, you have a First Amendment. Now, all amendments, no amendment is absolute. You know, Trace, the First Amendment, defamation. I can't defame you, right? Because ultimately I would be liable. Second Amendment, right to bear arms. Right to bear arms. In that amendment, it means that you can regulate firearms. It doesn't mean I can have an Uzi in the studio. So you have to balance the First Amendment with the rights of a client to know. And that's what it was challenged on. It was challenged on First Amendment grounds, whether or not a doctor could disseminate this information to a client. And the answer is yes, this judge will be reversed.
Joey, West Virginia.
Rebecca, we got to go. It's a great debate. We thank you both, former prosecutor Joey Jackson. I know.
Not Joey.
Same bat channel. Criminal defense attorney Rebecca Nitkin.